Namaste, good morning. Welcome to episode number 178 of AAA Weekly Webinar Series. We are continuing with our process of discussing clause by clause the Insolvency and Bankruptcy Code Amendment Bill 2025. So we will not waste any time today, and we will just try to complete one part of it. And we would be discussing the waterfall mechanism, where there is a huge change, and that actually is impacting the overall insolvency in a great manner. So we would be discussing that and some of the consequential amendments into pre-packaged insolvency resolution process. So let us talk about section 50 subsection 1 regarding the extortionate credit transactions, and it is only about look back period in sync with section 43, section 45 or 46. So there is a look back period, and the look back period is 2 years in the case of extortionate credit transactions. However, this 2 years now, it will start from the day the application is filed and not from the date of admission or initiation of CIRP. That is the difference. And since the difference is again in sync, we have already explained in the last episode the impact of this amendment in section 43, in section 45 or 46. So the same impact in section 50 also. So there was a tendency of delaying admission only because all those key personals or the management wanted to get out of this look back period. So therefore, it was also recommended by, so the amendment is very small, that it will be now the look back period will start, look back period will start, and this will also include that period when the application is submitted to NCLT and the commencement is started, and thereafter it is 2 years. So in case the application is submitted today to NCLT and the admission order is exactly after 1 year, and then therefore the look back period will be 3 years from the date of commencement of the insolvency. So now this was also, like as we discussed in section 43 and section 45, this was also a recommendation of Insolvency Law Committee recommendations 2022, and in fact the report in fact explicitly recommended aligning the look back periods for all avoidance transactions, section 43, 46 and 50, to start from the initiation date, that means filing date, rather than the insolvency commencement date. This was to address the zero period vulnerability where the debtors would exploit admission delays to enter preferential, undervalued and extortionate transactions. So this was also a kind of observation in the case of Anuj Jain and J.P. Kensington by Honorable Supreme Court, and the delay in admission, in fact, was like kind of most of the promoters, they were they were in fact going out of the look back period. So therefore, this amendment, in fact, is again in sync with all other three amendments. The gap period is covered, and it is consistent with section 43 and 46, and it is also a kind of stronger creditor protection. Now, going to section 52, which is a section which is the secured creditor, regarding secured creditor in liquidation proceedings. And this is a section which is the relinquishment of security interest in favor of the liquidation state. So the present provision is where the secured creditor realizes security interest under clause B of subsection 1, he shall inform the liquidator of such security interest and identify the assets subject to such security interest to be realized. Now, the proposed amendment is, first of all, the creditor will identify the asset and will inform the liquidator within a period of 14 days from the liquidation commencement date. Although these days were being managed by IBBI through regulations, but this has been codified now. earlier in the regulations, it was 30 days, but now as per this code, since the overall liquidation period is reduced, so they have also reduced it to 14 days as against 30 days, which is provided in the regulations as of now. However, this has come to the code, so therefore there will not be any litigation on this. The secured creditor will have to identify the asset, will have to prove the security interest, and then will have to inform the liquidator within 14 days whether he would like to relinquish the security interest in favor of the liquidator or not. Then, provided that where more than one secured creditor has any security interest over an asset of the CD, no secured creditor shall be entitled to realize its security interest unless the realization is agreed upon by the secured creditors representing not less than 66% of the value of all claims that are secured by that security, that property. So the 66% of all those creditors who have security interest on that property or that asset or those assets, all of them have to decide by way of a voting. If 66% decides to relinquish or not to relinquish, that will be implementable. In case the 66% are not able to decide anything, then it automatically will vest with the liquidation estate. Now, this is again, it has a kind of background. Now, the judicial influence, in case we talk about, it is a case of State Bank of India versus Anuj Bajpai. It is NCLT case. In this particular case, the SBI wanted to opt out of the liquidation process and realize its own security interest independently. However, the liquidator raised concern that the SBI might sell it to related parties. There was no clear timeline for when SBI had to inform. The process lacked checks and coordinations, especially when multiple creditors were involved, and CLAT upheld the liquidator's right to impose conditions and emphasized that even secured creditors opting out must respect the broader objectives of the IBC, including transparency, fairness, and protection of public interest. So this amendment has contributed, one, that the SBI delayed informing liquidator, now that stands completely cured. The proposed amendment introduced a 14 days timeline for secured creditors to modify the liquidator, to notify the liquidator, preventing such delays. Now, the SBI wanted to sell assets to potentially ineligible parties. Now, the amendment, in fact, reinforces that the assets cannot be sold. That is already there in the regulations. That is not in the amendment, but that is in the regulations. So, therefore, in case the asset or assets has multiple security interest from multiple creditors, then 66% is decided. In fact, in one of the case, like Shrikant Dwarkanath, liquidator of Surana Power Limited versus BHEL, that was again long back in 2020, when NCLAT decided that they took the advantage, the provisions from SURFACI, where the 60% of the secured creditors collectively decide. So in that case, it was decided by NCLAT that if 60% of the secured creditors decide in favor of relinquishment or not in favor of relinquishment, that will be acceptable by the liquidator. So based on all this judicial pronouncement, regulations, but now the same has been codified. It is actually, it will expedite the liquidation. It also has introduced a procedural discipline. It has also prevented, it will prevent indefinite delays in asset realization. And if no decision is conveyed to the security regarding the relinquishment, it actually will stand as if it is relinquished automatically to the liquidation estate. Then it is preventing like further delays, ensuring collective decision making. So this is what is the impact of this judgment. Important, very important. Next amendment is section 52, subsection 8. Again, the existing provision says the amount of insolvency resolution process cost due from secured creditor who realize their security interest in the manner provided in this section shall be deducted from the proceeds of any realization by such secured creditors, and they shall transfer such amount to the liquidator to be included in the liquidation estate. it was only insolvency resolution process cost. There was no mention of liquidation cost. There was no mention of workman dues. Workman dues are payable because the workman dues are in fact they are standing pari passu with the secured creditor. So their rights in fact would actually be compromised in case the secured creditors take away all their assets to be sold independently, either under SARFAESI or any other law. Therefore, and secondly, there was disputes in many cases that the liquidation cost is not supposed to be shared, as the liquidator has not done or has not provided any service for the sale of these assets, because the secured creditor is doing it themselves or itself. Now, the amendment is that the amount of insolvency resolution process cost, liquidation cost, and workman dues, respectively, shall be deducted from the proceeds of any realization by the secured creditor. And this is what is the amendment. So let us understand again the background, what prompted this amendment. So the first prompting was done by the Insolvency Law Committee, February 2020 report, where at page number 27 of the report, in fact, talked about the payment of liquidation expenses. The committee discussed whether a secured creditor that opts to stand outstanding outside the liquidation process under Section 52 should be mandated to bear a share of the liquidation cost as well, as is currently provided for the liquidation regulations, currently provided in the liquidation regulation. IBBI was managing this lacuna through regulations. And in fact, as liquidator, we have been recovering liquidation cost as well as the CIRP cost from the secured creditor who in fact intimate the liquidator that they would not be relinquishing their security interest in favor of liquidation estate. So therefore, the committee in fact decided that this amendment should come. So therefore, this amendment has come. So this is basically equitable contribution by all secured creditor. That is what is the impact of this amendment. And it is also more or less codification of what the judicial pronouncements have decided, and also what the regulations have said. So therefore, it is now brought to the code. It has been codified so that there is no dispute over it. So therefore, the secured creditor will now share the CIRP cost, liquidation cost, and workman dues. Workman is also protected. So therefore, no cherry picking would be possible. Otherwise, there was a possibility that the secured creditor will not relinquish their security interest in favor of the liquidator or in favor of the liquidation estate, and all those liabilities will come to the liquidator and the assets will be taken away from the liquidation process. So therefore, it has now assured that within 14 days. Number two, the cost, it will not impact the cost. Number three, when we talk about the Section 53, it will be seen very clearly that the secured creditor definition has also been changed. Therefore, the secured creditor will not have any apprehension how the proceeds will be distributed to the secured creditor in case they're relinquished in favor of the liquidation estate. Therefore, that confusion is already over because of that amendment in Section 53 of the IBC. Then timely liquidation is also in this manner, it is assured collective. So therefore, the maximization of the value would also be possible because the committee of creditors will oversee the liquidation process. The committee of creditors will collectively take a decision, and also the transparent process of auctions as introduced by banknut.com, that also has contributed in fair competition and also transparent competition in liquidation processes. And now we feel that the liquidation can be completed within timing unless the assets are attached by any enforcement agency. Otherwise, there is nothing which actually stops now the timely liquidation. However, in many of my cases, the one is the stay by some court to attachment by investigating agencies, and three is the avoidance transactions. These are the only thing which has actually delayed many liquidation processes, and therefore the now with these couple of amendments, the liquidation process will be very, very smooth. Now, in Section 52, subsection 9, again, there is an explanation which has been added. and that explanation has been added only for subsection 2, not for all the sections. Subsection 2, now it says section 52, subsection 9 says where the proceeds of the realization of the secured assets are not adequate to repay debt owed to secured creditor, the unpaid debt of such secured creditor shall be paid by the liquidator in the manner specified in clause E of subsection 1 of section 53. Now, the explanation which has been added, that is the, for the purpose of this section, it is hereby declared. So this is it says that the amended provision, like what are the amended provision? Amended provision is, first is 14 days. One is 14 days period, 14 days period, and then we actually can see the 14 days period is one amendment, and the other amendment is 66% the collective decision. So these two amendments will have effect only after this bill is passed by the Parliament. Not having it is not having a retrospective effect, because see, all other amendments are more or less was there in the regulations. However, this section 50 subsection 2 of section 52, where this 14 days is mentioned, and also 66% for collective decision, this will be prospective. It will not have any retrospective effect. Now, therefore, I think it is all clear now, and we in fact have to move to very important, in fact, as I say, the very important means the very important amendment of this bill, and that is in section 53. And I will actually, before I say something about section 53, I would like to talk a little about what are explanations and illustrations. Because see, the amendment which is proposed in this bill are through in section 53 are through explanations and illustrations. So we tried to study about why these are being made through explanations or illustrations. So we found a lot of material on that. One, that the explanations inserted in statute are usually clarificatory in nature. They are meant to explain what the legislature always intended the main provisions to mean, and to remove doubt or conflicting interpretations taken by courts or tribunals. So therefore, the explanations means that these are clarifications only to clear all doubts or all kind of conflicting interpretations. That means when an explanation is inserted, that means all existing cases which are pending before any court, that would be decided based on this explanation, because the law is clarifying that this was the intent of the lawmakers in the main provisions itself. Not this is not a new provision. It is an explanation of the main provision, which is in fact, which was accordingly, it was promulgated in 2016. So therefore, all existing cases whatsoever, wherever these are pending, this explanation will be applicable. Then even the illustrations serves as an example to guide application of a provision. These are not substantive law by themselves, but they help adjudicating authorities apply this section consistently. Now, see, like when we say that this whether these would be prospective or retrospective, so one, that these are not substantive amendments which creates new rights or liabilities. So these are generally prospective. In this, when we have substantive amendments which are creating new rights or liabilities, these are normally prospective and cannot be retrospective. However, the explanations or clarifications or even the illustrations are in fact retrospective, because they do not change the law, but declare what is always meant. Courts have repeatedly held that when an explanation is inserted to remove ambiguity, it relates back to the original enactment. Illustrations usually follow the same principle. They clarify how this section has to be applied from inception. Now, it will have the effect on pending cases. If the amendment is by way of explanation or illustration, courts and tribunal will normally apply it to all pending cases as well. Since it is declaratory, of the existing law. If the amendment is substantive, like introducing a new time limit or new rights or new liabilities, that cannot be retrospective. Now, there are many, in fact, judicial pronouncements on this. The courts have drawn a distinction between clarification and substantive amendment. So, in fact, Jile Singh versus State of Haryana in 2004, the Supreme Court has decided, and it held that the clarificatory amendments are retrospective. And in the case of Sedco Forex International versus CIT, in 2005, the Honorable Supreme Court has decided that the substantive law is prospective, but clarificatory is retrospective. Under IBC, when this explanation to Section 5, subsection 8, clause F was inserted in 2018 to cover home buyers, it was decided by Honorable Supreme Court in Pioneer Urban Land versus Union of India that it was upheld that it was clarificatory. So even the original main provisions had the same intent. Now, with this detailed discussion on explanations and illustrations, now we would like to see how the Section 53 is amended. In Section 53, subsection 1, A is the insolvency process and the B is the debt, which is workman debt and the secured creditors debt, and an explanation is added here. After Section 53, subsection 1, clause B and subclause 2, after that, an explanation is added, and that explanation says, for removal of doubt, it is hereby clarified that where this value of security interest relinquished by secured creditor is less than the total debt owed to such secured creditor by the corporate debtor, he shall be a secured creditor to the extent of the value of such security interest. To the extent of the value of such security interest determined in such manner as may be specified. Now, specified means that we will get the regulations. Regulations are awaited. So when the regulations will come, we will actually come to know how the value of the security interest will be determined. And for the remaining value of such debt, he shall be considered to be an unsecured creditor. So whenever, after this explanation, whenever we receive a claim as RP or as liquidator, our first job will be to see whether there is a security interest or not. If there is a security interest, identify the security. Then we also have to see what is the value of that security. That means the valuation, we will see the regulation. So that means the admitting a claim will depend upon the valuation of that security interest. Now, in case the RP has taken the control and custody of the assets and the business of the company, and there are working capital facilities, and the working capital facilities, hardly there is any stock. That means that the working capital lending, they would actually have the inferior treatment, because see, the working capital will be the first one to dilute. The working capital assets will be the first one to kind of vanish. So therefore, the admittance of a claim would become very difficult. Everyone will fight on the valuation, the method of valuation. They would like to, all the creditors will like to have meeting with the valuers. They would always insist that the value of my security is higher. They will always insist that the liquidator or the RP has not carefully taken the stock of the inventory and the other items, even the consumables. So they would like to increase value of their security so that their secured part increases. So this is, we will manage, we will see when the regulations will come. However, with this amendment, there are two things that we were struggling for the last, say, 7 years. When we distributed the first the proceeds under the liquidation. Since then, we are in fact kind of, it was my case which actually gone to the NCLAT, that is Technology Development Bank versus Anil Goel, in a case of a very small company called Gujarat Oleochem Limited. In that case, I distributed considering value of security of each secured creditor. I also considered the priority of charges. And the NCLT Ahmedabad, in fact, said that the liquidator has done rightly. However, the NCLAT said that Section 53 does not have two classes. It has only one class. And also Section 53, subsection 2 says that if there is any arrangement between the secured creditor, that has to be ignored. So therefore, no. With this amendment and also with the amendment of Section 53(2), now the liquidator will see the value of security, because based on the value of security, the amount of secured debt will reduce. And then the liquidator will also see the priority of charges. So that is something which is important here. And in fact, I would like to say that the second amendment which has come, that is after the subclause E and again clause I, another explanation is added, and that is regarding the statutory liabilities. See, in clause E, it is very clearly written that any amount due to central government and the state government, including the amount to be received on account of the Consolidated Fund of India and the Consolidated Fund of a state, if any, in respect of whole or any part of the period of 2 years preceding the liquidation commencement date. So, for all those dues of up to 2 years, there is a priority which is called priority E. Priority E, and then it is also pari passu with those unsecured part of those secured creditors who have not relinquished their security interest. So this is again pari passu with those creditors. Now, an explanation is added here to clarify the statutory liabilities, and that clarification is also very important. For removal of doubts, it is hereby clarified that any amount, whether or not a security interest is created to secure such amount, due to central government and the state government in respect of whole or any part of the period of 2 years preceding the liquidation commencement date, shall be distributed under this subclause, whether secured or not, whether have a security interest or not, whether the security interest is created or not. It will be considered in this subclause E only. It will not shift up. It will not shift up. It will not go to along with the secured creditors. And any remaining amount, whether or not a security interest is created to secure such amount due to central government and the state government, shall be distributed under clause F. Under clause F, we can see under clause F is basically the along with the other operational creditor. Along with the other operational creditor, that is what is the clause F. So therefore, what we are trying to say, this clarification, in fact, has completely put on rest the judgment of State Tax Officer versus Rainbow Paper Mill. This judgment, in fact, which is still pending, a curate petition is in the case of State Tax Officer versus Rainbow Paper Mill is still pending before Honorable Supreme Court. However, this amendment bill clarifies that the government dues, even if secured by statute, do not override Section 53 Waterfall mechanism, reinforcing the priority of insolvency, cost, and the workman's dues and the secured creditor. And also, this particular judgment, which has actually impacted a lot of distributions. In fact, as the question of law which is pending before Honorable Supreme Court, one in my case, which is Technology Development Board versus Anil Goel, that is Gujarat Oleochem Limited, that is pending, and there are other cases which are tagged. In fact, the Stressed Asset Stabilization Fund of IDBI versus Technology Development Bank is also the same case, but they are tagged together. And the third case which is tagged together is Bala Techno Industries Limited, and the citation of the case is Oriental Bank of Commerce, now PNB, versus Anil Anchalia, And the fourth case, which is tagged with this, is IFCI Limited versus IDBI Bank, which is basically in the case of IVRCL Limited. Now, in this case, in all these cases, the only matter which is tagged down is whether the value of security and the priority of charges would be considered by the liquidator or not. And in all these cases will be settled and will be decided only after the amendment bill is passed. There are many other cases, and there are many other stays which the Supreme Court has given on such distribution. Because the State Bank has gone to Supreme Court of India in the case of ST Aluminium, where NCLT and NCLAT has passed an order that the distribution has to be based on pro rata, based on the total claim, not based on the value of security, not based on the priority of charges. However, State Bank of India went to Supreme Court of India, and the Supreme Court in fact said that till the time this decision is taken, the redistribution will not happen. In fact, NCLT and NCLAT in fact had ordered that the redistribution must be done, because the liquidator in that case also belonging to AAA, the liquidator said that we would be distributing based on the priority of charges and based on the quality, the value of security interest. NCLT said no, you have to go as per the Technology Development Bank versus Anil Goel, which is a judgment of NCLAT. And NCLAT also said, because they have no other option, because they have already passed an order, they will have to follow till the time Supreme Court decides. So therefore, everything is pending. So there are a lot of litigation pending. So all those litigation will come to rest. And in case it has been distributed as value of security and priority of charges, it will be considered as valid. And in case it has been distributed other way, then the redistribution will happen. Supreme Court will decide this case after the amendment bill. Now, there is no possibility that it will be decided before the amendment bill is passed. Now, impact of Section 53 is that the lot of litigation will go away, time-bound liquidation, and the speed and certainty will be there. And you see, basically now, coming to Section 53, subsection 2. Now, let us see what exactly the Section 53, subsection 2 says. Any contractual arrangements between recipient under subsection 1 with equal ranking, if disrupting the order of priority under that subsection, shall be disregarded by the liquidator. Shall be disregarded by the liquidator. So it was actually the NCLAT interpreted this particular subsection as that if there is a arrangement between two creditors, that I will have first charge, and the second party says that I will have second charge, and there is a third party which says that I will have subservient charge. All this is called arrangement, contractual arrangement between secured creditors. However, it is said that the liquidator will disregard it. Now, in case the liquidator disregard it, that means that any person who has second charge, third charge, fourth charge, subservient charge will also have pari passu charge. That actually will impact the industry, will impact the banking industry, economy very adversely. So therefore, the Supreme Court has not taken a decision. The Supreme Court was waiting for this kind of clarification. And now the illustration has been proposed. And the illustration number 1, because there was a fear that the secured creditor can always enter while giving loan in a company, that they can actually say that we will have an arrangement with the workers that in case of a default, the secured creditor will have first right and the workers will have a second right. In case any such kind of agreement or arrangement exists, that shall be disregarded. So that means that nobody can say that the workman rights can be taken away only by way of an agreement or an arrangement between the creditor and the workman, because they are having the same priority. Coming to illustration number 2, which says, illustration number 2 says this shall not be regarded. No, what is this? The illustration number 2 says the X, a creditor, has a contractual arrangement is Y, another secured creditor. As per the arrangement, the debt owed to X shall be cleared before clearing the debt owed to Y. This is called first charge, second charge. And there can be another party also, X, Y, Z also, and there can be multiple parties. So they can have second charge, third charge, subservient charge. But now they say the liquidator this arrangement shall not be disregarded. Shall not be disregarded. So that means anyone who has a second charge will wait for the first charge to be clear first. So that means if the value of the security is less and it is not even sufficient for the first charge, then the Y then the Y will be unsecured. Then Y will be unsecured. And in case the value of the security is slightly more than the debt of the X, so for example, the value of the security is 100 and the debt is 90, then for Y, 10 will be the value of security interest, and the Y will be secured to the extent of 10 and not to the extent of his full debt. So these illustrations are in fact clarificatory, and this will in fact resolve too many disputes. Statutory priority is protection. We have now seen that in section 53, the statutory dues will have the same place as it was intended originally, which is the fifth place, which is in subclause E. Also, the inter se creditors, the creditors inter se flexibility will continue. And that kind of arrangement will continue in the economy, in the banking industry. So the first charge, second charge, subsequent charge actually would still be possible. Otherwise, it was getting disturbed because of this section 53, subsection 2. It is, I believe, I would actually finish the section 53, which is regarding the dissolving the company. And before I would move to pre-package some of the amendments, then I will take some questions. Now, let us understand section 54. I have explained the section 53 completely. Now, section 54 is regarding the dissolution of the corporate debtor. The existing provision, which is section 54, subsection 1, says where the assets of the CD have been completely liquidated, the liquidator shall make an application to the adjudicating authority for dissolution of such corporate debtor. And now let us see what is proposed. Now, the proposed amendment says the liquidator shall completely liquidate the assets of the corporate debtor and make an application for its dissolution to the adjudicating authority within a period of 180 days. Within a period of 180 days, that means the liquidation period is also restricted to 180 days. You will see the way I'm trying to look at this particular section, you would see that the liquidations definitely will close now within this period. Be careful about the liquidation process. In fact, is something which is you would see actually is completely whitewashed. All kind of errors are removed, all gaps are removed, and the liquidation process would be the most successful in the entire process. And then we also have something which is very unique, which is creditors initiated insolvency resolution process, that we will discuss in the next episode. That's a very, very unique thing, and that actually is kind of a complete change in the banking industry, and the banks will definitely love to use that CIIRP, creditors initiated insolvency resolution process. However, coming back to section 54, only 180 days from the liquidation commencement date. However, on an application by the liquidator along with sufficient reasons, extend the stipulated time period, but not exceeding for 90 days. So 180 plus 90 days. So that is the only time available now, and the adjudicating authority will not extend any time beyond this. Where a proceeding in respect of avoidance transaction or fraudulent or wrongful trading or under section 47 is pending before an application is made, or a decision like section 33 subsection 2 says that the RP, the COC can decide to dissolve a company even much before that. So that is also covered here. But in case there are any kind of application under section 43, 45, 46, 49, 66, 50 pending, then the COC shall determine the manner of pursuing such proceedings and the distribution of the proceeds arising out of such proceedings in such manner and subject to such conditions as may be specified. So what the COC has to do, COC will actually determine the manner of pursuing these proceedings and the distribution of proceeds arising out of such proceedings. This was there in the regulations, but now it has been codified. So therefore, the NCLT will not allow more than this period unless there would be some kind of attachment or the liquidator is not able to play the game. So then it may be possible that this adjudicating authority may extend. Now, subsection the C54(1)(b) where any suit or other legal proceedings against the corporate debtor in respect of any proceeds to be distributed under Section 53 is pending before the application, then the committee of creditors shall make appropriate arrangement for pursuing such suit or proceedings and distribution of proceeds to the parties in such suits or proceedings. Now, this is important to understand. One, first of all, there is a word called any suit or other legal proceedings against the corporate debtor. Against the corporate debtor in respect of any proceeds to be distributed. So one, that the distribution disputes under Section 53 is pending. If the distribution proceeds are pending or a decision is made to dissolve the company, then that is also the COC has to manage. They only have to see the arrangement for pursuing such litigation, such proceedings, such suits, and distribution. That is also something that has to be done. Now, the only question that I'm trying to say that it actually shows that if there is any asset still available and this time of 180 days and even 90 days is expired, PUFE transactions all being managed by the committee of creditors. Any kind of dispute regarding distribution, any proceeds to be distribution, that also will be managed by the committee of creditors. But then what happens? Like I would come to that, but in the, see, for the time being, we are only saying that it is 180 plus 90 days. This is a faster closure, and the COC authority in any case is very important. And then we move on to Section 54(2). And that says the existing Section 54, Section 2 says the adjudicating authority shall on an application filed by the liquidator under subsection 1 under order that corporate debtor shall be dissolved from the date of that order and corporate debtor shall be dissolved accordingly. Now, in this, the proposed amendment is without prejudice to the presence of subsection 2, the adjudicating authority may, on receipt of decision of the committee of creditors to dissolve the corporate debtor under Section 33(2), order that the corporate debtor shall be dissolved from the date of that order and the corporate debtor shall be dissolved accordingly. However, there is a proviso added. So the proviso says, provided that if on the passing of an order under this subsection, any asset of the corporate debtor remains with it. On passing of an order under this subsection, any asset of the corporate debtor remains with it. Such asset may be disposed of in such manner as may be specified. That means that we would await for the regulations. So the question that I am trying to understand from this amendment, which is the amendment of section, insertion of Section 54(2)(a). 54(2)(a) is a very important insertion. It says that if there is any asset in the company, the NCLT will still dissolve this company. Will still dissolve this company, will pass the order for dissolution. And that asset, whatever is left, how that will be disposed of, we will see the regulation. The regulation will come. But the company will be dissolved. Whatever assets are there, that will be sold later on after the dissolution of the company. We will wait for the regulation, and the proceeds thereof shall be distributed for payment. First of all, the insolvency resolution process cost will be paid and the liquidation cost will be paid. And if any surplus remaining after payment of such cost shall be credited to the insolvency and bankruptcy fund formed under Section 224. That means if there is any delay, the company will be dissolved and that asset will vest with the IBBI's regulations. Let us see who actually will sell those assets, and the proceeds will go to Insolvency and Bankruptcy Fund, which is formed under Section 224 of IBC. So that means the creditors will lose that asset. However, the CIRP cost and the liquidation cost will be paid out of that part of the sale. But the liquidation will not stop. The dissolution will not stop. PUFE pending, company can be dissolved. Any distribution disputes pending, company can be dissolved. Any asset pending, company can be dissolved within 180 plus 90 days. So that is what is my understanding about all these amendments. Even if there are assets, and those assets, That means that assets are not possible to sell. And then finally, the structure will be made by IBBI. That structure will sell those assets. Another clause 2B, notwithstanding anything contained in subsection 2 and 2A, the passing of the dissolution order shall not affect the continuation of the proceedings. That, of course, is there. Even if the dissolution order is passed, the POFE proceedings, it will not impact. It will continue. Any proceedings for distribution of proceeds will continue, and the company can be dissolved. And any asset will be sold by, we'll see regulations. In the regulations, the IBBI may even propose any kind of authority to sell those. Now, like if I try to see the questions at this moment, security interest, Lalit Maheshwari ji is asking, security interest of first charge, second charge, and pari passu charge have same meaning as secured creditors or otherwise? No, presently section 53 subsection 2 says that this is called arrangement between creditors, that I will have first charge, you will have second, and you will have third, or we will have pari passu. All this is an arrangement. See, as far as the pari passu is concerned, that's not a problem. But as far as this first charge, second charge is concerned, that presently says that it will be disregarded. Disregarded means section 53 subsection 2 says that all will be pari passu. All will be pari passu. So now with this amendment, it will now, the first charge will have the first right, second charge will have only in case there is anything surplus after the first charge is completely vacated. So Mr. Rajan Chakrabarti is saying is, what is the stage of these amendments, when it would be notified? Now, presently this bill, Insolvency and Bankruptcy Code Amendment Bill 2025, this has been referred to a committee, and probably the committee will submit a report, and this bill will come for discussion in the winter session. Hopefully, it should be passed in winter session. So therefore, all these disputes, all these pending litigation will only be decided after that. Now, Deepa Murthy is asking, does the amendment result in same realization by secured creditors, whether they sell the secured assets outside liquidation or relinquished in liquidation estate? Yes, after this amendment, the secured creditors will have the same realization, even if they sell through the liquidator or they sell of their own. Because see, if they have the value of their security interest, they will be considered secured. And there will not be any difficulty because they will have their security. They will have the value of their securities. They will be given the value of their security. Then Mr. Rajan Chakrabarti says whether the workman dues would have to be paid in full or proportionate. Workman dues, as provided in this section, would be proportionate to secured creditors. I'm not talking about the Provident Fund. I'm not talking about the gratuity, and I'm not talking about the even superannuation fund. So these are outside the liquidation estate, but I'm talking about the workman dues. Workman dues having the same priority as the secured creditors. So they would be proportionate, the same proportion as the secured creditors will have. Mr. B.S. Rathi is asking the question, is there any bar on making changes in law with retrospective effect, or it does not look good that the lawmakers did not think earlier, it is being done through explanations? No, by doing it through explanations also mean that whatever present litigation, whatever pending litigations are, all those would also have the impact of these amendments. Now, let us think about a situation that in section 53, if the value of security interest and the priority of charges are not considered, then the entire banking industry actually will, their interest will jeopardize. And that will impact adversely the entire banking industry. So therefore, it has not impacted so far. Therefore, the intent of the legislature is shown in this explanation, so that the distribution, whatever has been done so far, that and litigation is pending, whatever has been absorbed and accepted, that is over. But wherever the litigation is pending, it will be redistributed considering the value of security of each secured creditor and also the priority of charges. It will be redistributed only after when this amendment will be passed. Again, Mr. B.S. Rathi is asking, please then Mr. The Kotak Delhi people. So after amendment now, the secured creditor who have higher security value used to not relinquish will relinquish to the liquidation estate. Yes, after this amendment, everyone probably will relinquish to liquidation estate, because one, that they in any case will have to pay the cost of the liquidator. And in case they do, in case they try to realize themselves, then they will also have to make effort and expenditure. So there will be dual cost. So therefore, everyone would like to relinquish in favor of liquidation estate. And there will be no benefit for the secured creditor of being not relinquishing. Yes, there will not be any benefit of not relinquishing in favor of liquidation estate. That's very clear. And this proposed amendment is very, very impactful. Then we actually have Mr. Kabir Singh Rajveer. It says that in case of any dispute between Supreme Court and the liquidator and IA is pending, whether the company can move for dissolution and what will be the status of cases filed. In case the dispute is regarding the distribution, that is something the Committee of Creditors will have to decide. Number one, how these proceedings will be managed and who will manage and who will bear the cost. And third, how it will be distributed. So that means that whenever the dispute will be decided by the court, the distribution will be that way. So this is what the Committee of Creditors has to decide, and then the company can be dissolved. And there is one anonymous attendee says that, is it possible to conclude liquidation process in such a short duration when the asset of the CD is attached by the ED and there is no clean slate theory under liquidation? Now, liquidation also has a clean slate theory. I don't agree that the liquidation doesn't have a clean slate theory. Section 32A is very powerful. However, as far as this enforcement directorate is concerned, enforcement directorate is releasing the assets in case those assets are belonging to liquidators. Now, what the enforcement directorates are saying, that you file an application before the special court under section 8, subsection 8 of PMLA Act, and then they will give consent to the court, and that those assets will be released in favor of the liquidator. The liquidator will sell. Liquidator will not sell to those parties who are promoters, who are accused, and who have some role in abatement of that crime. Other than those, the liquidator can sell to anyone, and the liquidator will distribute to the proceeds to the stakeholders. So that is what the ED is doing. So therefore, now ED, in fact, has also kind of changed their mind. So in fact, in many of our cases, in fact, 13 cases, Nirav Modi, the Mehul Choksi, Mehul Cheksu cases, Nirav Modi, all companies, Mehul Choksi, all companies, RA Agro, Varsana Ispat, Visa Power, and now Rotomac. In all these cases, the ED has released the assets in favor of the liquidator, and we are able to sell it, and we are able to distribute the proceeds. So the ED is also not a question now. Now, Mr. Kabir Singh is again asking whether there is a provision under the current rule that the liquidator can revise the claim of the secured creditor after 1 year. There is a provision in the regulations that it can only be revised, I think, up to 90 days. If I'm not mistaken, it can only be revised up to 90 days. And if that is revised within 90 days, that should be accepted by the liquidator, looking into the genuineness. Otherwise, any revision is not allowed. Mr. Sadasiva is asking, how will the PF payment be made when all the assets by the secured creditors are not relinquished? As I said, the amendment is now proposed that the liquidator will have the right to recover, the workman dues. Of course, that workman dues which is mentioned in the amendment is only workman dues as per section 53, subsection 1, clause B, subclause 1. That is the only which is mentioned in. However, since this provident fund is not even part of the liquidation estate, not even the part of the liquidation estate, and in case there is nothing in the liquidation estate, if there is nothing in the liquidation estate, that means those provident fund and that ESI and also, gratuity, provident fund and superannuation fund will also not be paid if there is nothing in the liquidation estate. If there is something in the liquidation estate, first it will be, nobody will say that the liquidator will not charge their fee. Nobody will say that the CIRP cost will not be paid. So my understanding is first CIRP cost and liquidation cost, then provident fund, gratuity and superannuation fund, and then comes the other secured creditors. That is the process in the liquidation realizations. Post see, Mr. RKJ is asking, post the amendment in section 53, what will be the impact of secured creditors having first charge and creditors having second charge? See, when the second charge was taken by the secured creditor, it was very clear that first charge will have the first right, and then thereafter the second charge will have the right. So there will not be any change in the understanding. In the same understanding when the loan was given, the same way the distribution will happen. However, there was a disturbance in between when this Technology Development Bank versus Anil Goel order came by NCLT, and by also because of the way the code with section 53 and section 53 subsection 2 was drafted, that was in fact creating the disparity and interpretation problem. So therefore, after this amendment, it will be same as it has been right from the beginning. In fact, the Sidco Leather versus ICICI Bank, in fact, 2005, the Supreme Court decided that the first charge value of security that was discussed in that Supreme Court order, and it will be the same even now. Then the another question is, the CS Lard is, if the liquidator wants to file dissolution application while PUFE transactions are pending, in such situation, the liquidation bank account need to be closed or continued. The liquidation bank account will be closed, and whatever money is there in the liquidation bank account, that can be transferred to any account as approved by the committee of creditors, and that can be a joint account, that can be a joint account with the creditors, or even that can be an association of person with any 2 or 3 persons. So that there are different structures which are actually possible. So that actually can be decided depending upon a situation from time to time. Mr. Sagu Tour is asking, sir, if the secured creditor not relinquishing security interest need not contribute for the liquidation fee, am I right? No. The secured creditor, in case he is not relinquishing the security interest in favor of liquidation estate, he will have to pay 3 things. 1, CIRP cost in case he has not paid. 2, the liquidation cost. And 3, workman dues. Even today, he's paying only because of the various judgments, and in future it is being codified now. It is very sure that there will not be any litigation on this, and also 14 days is the period when they have to relinquish the security interest. Again, Mr. Ravi is asking, with voting rights of the unsecured creditors, second charge holders still in proportion, they may disrupt the approval of the resolution plan. So if there are secured creditors and unsecured creditors, and a resolution plan is received, at that time, the COC and the RP has to play a role, so that the unsecured part of the creditors is also given some importance, so that they vote in favor of the resolution plan. Otherwise, in liquidation, the unsecured creditor will not get anything. So they are now out of the ambiguity. So in case they get slightly more than their share, what they would get in liquidation, they would approve the resolution plan. That's what is my feeling. So this clarity in the law will actually would be very, very important, and this will actually resolve many disputes. Anonymous attendee says, based on the explanations, can cases already decided against these explanations be appealed in higher courts? There is a time for filing appeal, and if that time has lapsed, there is no possibility of filing appeal now. So that's what, like, I have finished all the questions, but in case there is any further question, actually I would like to finish this very, very small part, which is some changes in the PPIRP, privilege, so that's one. 54(2)(b I've already done. 54(3) is okay, consequential. That is also consequential. 54(4) is also consequential. So this is all. So we actually go to section 54A regarding pre-packaged insolvency resolution process eligibility. So that is only consequential. It is now the creditors initiated insolvency resolution process, CIIRP, is also added, because there is a new structure which has been added, and which is such a powerful structure that I will come in the very next episode. We will discuss only CIIRP. That is the structure which is most powerful. The bankers will have such power. They have never imagined that they will get this kind of power. So this is again a consequential amendment. So not like having any impact on pre-packaged insolvency resolution process. And the another part is that in this section 54C, there were various documents which was mentioned, which is supposed to be part of the application, part of the process. Now, all this has been taken away from the code and it will be managed through regulations. So section 54C, now it is saying that it will be specified. Specified means it will be managed through regulations now. And instead of, it will be very important for the IBBI to take the feedback and immediately make a corrective action through regulations. And therefore, this has been taken away from the code and it is now, it will be covered in the regulations. In this section 54F, the amendment is like, as we have seen the amendment in section 18 also, where the instead of personnel of the corporate data, now we have covered three kinds of parties. One, the persons who is or has been a personnel of the CD, or who is or has been a promoter, or who is or has been associated with the management, or who is or has been engaged in a contract for service. So all the past employees and present employees, all the past directors and present directors, all the past key managerial personnel and the present key managerial, all the past contractors, all the past professionals and present contract professionals, all will be available for the RP or for the liquidator to get information and to get kind of cooperation. Similarly, there are two sections which has been introduced in section 31. In section 31, two important sections have been introduced. One, since this the clean slate theory. The clean slate theory was not in the code; it was only through the judgments. So the clean slate theory now has been codified. So therefore, section 5 and section 6 has been added to section 31. Section 5 actually says, notwithstanding anything contained in any other law for the time being in force and subject to subsection 6, where a resolution plan has been approved under subsection 1, a license, permit, registration, quota, concession, clearance, or similar grant or right given by central government, state government, local authority, sectoral regulator, or any other authority constituted under any other law for the time being in force associated with such resolution plans shall not be suspended or terminated during the subsistence of the remaining period of such grants or rights, if the corporate debtor, or if applicable, the person whose resolution plan is approved under subsection 1 complies with the obligations in respect of the remaining period. So that is what is that all the basically license, permits, registration, quota, concessions, clearance, or similar grants will continue. And secondly, where the adjudicating authority approves the resolution plan unless otherwise provided in the resolution plan, any claim against the corporate debtor and its assets under any other law for the time being in force prior to the date of the approval shall be extinguished, and no proceedings shall be continued or instituted against the corporate debtor or its assets on the basis of such claims, including proceedings for assessment of the claims. So this clean slate theory and the protection of all the licenses, all main important approvals for continuing the business, that is also now added in the approval of the resolution plan. So that is that clean slate and the protection of the licenses is also added into pre-package. Then also when before rejecting a resolution plan, the one notice will be given to the committee of creditors for ratifying the defects. That is also there. And again, as I said, the liquidation order, in case it has to be passed, there are amendments which were there in the liquidation as well as in section 33(1), and those amendments are also applicable to PPIRP. And then 54F. That's very important. In fact, the fast track corporate insolvency resolution process, which was introduced in 2016 along with the IBC, that was applicable to small companies, startups, and unlisted companies and limited debt exposure. And it was having a shorter time period of 90 days, and it was extendable by 45 days. So in fact, it was hardly any case was admitted under this section. So this is totally proposed to be removed. So that is what all today from our side. If there is any question that I can take up, and then we can close our let me take the question from the last. Any amendment in offing in PIRP where RP delays the process if appointment through Section 94? We will come to the personal insolvency matters after we deliberate on CIRP. And then we also would have, there are many people they are saying, excellent session, thank you very much. Is there a provision for modification of liquidation value if CIRP takes a long time? Liquidation value, yes, in liquidation process also there is a possibility of getting it revalued, and depending upon the committee of creditors now, earlier it used to be SCC, the committee of creditors can decide to have a current valuation of all the assets, so therefore the liquidation value will change. Other question is from Mr. VK. Liquidation cost will be considered up to the date of realization of assets, and what about the cost incurred thereafter? My understanding is, and the practical view about this is, that the liquidation cost should be totally estimated, and based on the estimates, the liquidation cost can be recovered from that the secured creditor who actually is not relinquishing, and later on, in case there is any surplus or any deficit, that can be taken or given back. However, when we talk about liquidation cost, the liquidation cost will be full liquidation cost, full CIRP cost. It has to be recovered from the secured creditor who is not relinquishing. Mr. RKJ is saying, meaning thereby that if debt of the secured creditor having first charge is 100 crore and the creditors having second charge is 150 crores, and the compromise scheme under Section 230 is approved at 40 crores, creditors having second charge will not get anything. So compromise scheme under Section 230 Act is not an IBC issue. It is not under IBC. Section 53 is not applicable to compromise scheme. Compromise scheme is Companies Act. So Section 53 is not applicable to a compromise or arrangement scheme under Section 230 of the Companies Act. So therefore, this whatever we have discussed is not applicable to any scheme of arrangement or compromise under Section 230 of the Companies Act. Mr. C.S. Lard is again asking if there is a recovery after dissolution from forfeit transaction, where to credit it and how to distribute it. That is what the committee of creditors will decide. Because the liquidation bank account will close, the committee of creditors will say either we authorize one of the creditor, or there can be a trust which can be formed, or there can be like two people can make an association of person. Why I'm saying two people can make an association of person? Because in one of my case, there is a money which is 8 crores of rupees, and there are litigations regarding distribution. So if I tell the creditors that you take this money and you keep it in interest-bearing deposits, there will be some tax deducted at source. Whose account this tax deducted at source will go? So there are issues. So therefore, either it can be a trust or it can be an association of person, so that the PAN number is taken, so that all this money is kept in that account. All these are practical issues. Then if we can discuss that. So I believe it is thank you very much for the participation. Thanks a lot for so many questions. I think we can conclude, and it's in fact really enjoyable to actually answer every question. But I think still there are questions which are pouring in. I still feel like answering a couple of questions. Mr. Sagu Tour is asking, when as secured creditor by not relinquishing security interest realizes amount, how liquidator can charge fee on that amount when he did not realize, not distribute. So when this insolvency law committee was discussing this, and there was various situations which was presented before insolvency law committee, and one of the situation was that there will be many cases that the secured creditors will take away their property and the liquidator will be left with the liabilities. Then who will fund the liquidation cost? That will impact the entire liquidation process. That will impact the efficiency of liquidator. Liquidator will not be able to get their fee. So therefore, this particular suggestion was given by Insolvency Law Committee that the law should be made in such manner that all the recovery should be done collectively in a transparent manner, and all the different creditors should not take away their assets and try to sell it either private treaties or other ways. So therefore, it was considered as more transparent, collective, and also in favor of the liquidation process, and also faster, because now in case we see the amendments, we can see that yes, definitely it will be a faster. Selling on going concern basis, I believe after this amendment will be passed, the sale of the company as a going concern will be eliminated from the law, and there is another possibility that this a fresh CIRP can be can again be made. A kind of a CIRP can be again restarted, and that those provisions have come in the code. And once this bill will become act, after that, probably what my understanding is that the sale of the company as a going concern, that will be removed. Is there any case law now that the workman dues and the CIRP and the liquidation cost will be paid by the secured creditors relinquishing? Yes. Any secured creditor who actually is not relinquishing, there are various judgments of NCL 80 which says that the secured creditor who is not relinquishing will have to make payment for the CIRP cost, liquidation cost, and the workman dues. There are many judgments. So all these judgments and all the regulations finally has come to the court. So it's great. I think I'm getting some good words. So I'm motivated with these words. So that is what is my energy. So there are a lot of messages which says that we definitely it is really, really helpful. So I think with this, I take my day as fulfilled. And I also would say always that this is our way of learning. So thank you very much. It is concluded.